can you assure this court that even incidental, because the scope of challenge was that who has created this post and what was the cabinet decision, all these things are there and CBI to inquire. Incidentally, the power of the state to create supernumerary post would not be an issue before the Honorable Supreme Court. Matter was adjourned. Learned Advocate, erstwhile Learned Advocate General took a specific instruction from the Council for the State in the Supreme Court, say no, this much assurance it cannot be. Obviously, it cannot be given. The challenge before the court is that state's power to create supernumerary post is supernumerary. Then, obviously, this was deferred. Again, this same question was put. The affidavit, if it is that affidavit was filed, but I asked Justice the Advocate General that this is not meeting my query. There is no clear-cut answer to that. Now I know that it is very difficult to give this answer. You don't know, while hearing of this SLP, the Honorable Judge will not go into that question, that how you have, why it has been created. There is another question, how it has been created. There may be an incidental question. When the division bench, so far I remember, had made certain observation regarding this creation of supernumerary post. It is not that possibly that in respect of which, to accommodate which kind of candidates the supernumerary post has been created. The observation was covering your power to create in the division bench judgment. So challenge to the division bench judgment before the Honorable Supreme Court, unless takes a final shape, whether it would be proper to deal with the issue or not. This, I'm troubled by this issue now.
Milord, your Lordship has been pleased to, Milord, put it in a most confined way as it could be. Here, Milord, the challenge is page 300 of the writ petition and 302 of the writ petition. What is the challenge? That certain number of posts have been created, partly for the physical education teachers and partly for the work education teachers. And according to the writ petitioners, who are obviously unsuccessful persons, they now question the propriety of creating these supernumerary posts, as they call it. Please have a look to your...
No. As they call it means, are you not saying that this is a supernumerary post?
No, I'll come to that. Why it should not be called as supernumerary post, that I'll come to that. Now, please have a look to your Lordship's order of 18th of November 2022. But I'm bound to answer to your Lordship's query or the to clear your Lordship's doubt that whether the pending SLP is standing in the way of your Lordship hearing this matter or not.
Yes.
But kindly have a look to the order of 18th of November, when your Lordship was pleased to, my Lord, pass this order of injunction. Please take the second paragraph of the first page. The power of the government to create so-and-so supernumerary posts to fill up the post of so-and-so, including physical and work education teachers and non-teaching staff in the so-and-so schools, to accommodate the wait-listed candidates with the order of 19th May, as well as the validity and legality are under challenge in the present writ petition. Now, this is the challenge. Dr. Patro, Learned Counsel for so-and-so, submits that against the posts so created, the names of 514 candidates and 766 candidates have been recommended for appointment in the post of so-and-so, respectively, to the board. In creating such supernumerary posts, the procedure prescribed under the Act and the rules prima facie have not been followed. Therefore, so-and-so are restrained from issuing any appointment letters to the candidate in respect of the post till such and such. Now, this has been extended from time to time. Now, my Lord, whatever, my Lord, your Lordship was pleased to, my Lord, prima facie observe, my Lord, for the purpose of grant of this interim order, my Lord, we are all bound by that. Now, my Lord, this is of 2022. In the meantime, many other matters were heard, various other orders were passed, matters went to Supreme Court, came back, again went to Supreme Court, etc. Now, my Lord, the point that is being taken today is that a matter is pending before the Supreme Court. Therefore, this court should stay its hands in hearing this writ petition, on the ground that incidentally